So on day one of legalization, there are many outstanding questions about what is actually legal starting today and the rules around consumption and the penalties Canadians could still face if they run afoul of the new regulations. From Toronto, I'm joined by Paul Calarco. He's a defense lawyer and a member at large of the criminal justice section of the Canadian Bar Association. Mr. Calarco, thanks for joining me. Let me start, if I can, by asking you about the pardons process the government has unveiled today. There will be legislation to allow anyone with a past minor conviction for cannabis to obtain a pardon without paying a fee, but it's not the total expungement of records that amnesty advocates have been demanding. So what do you think of how the government is handling this?
This could be quite significant for domestic purposes. However, it may not have any effect on international travel, for example. And all the government has done is announce an intention to bring forward legislation. We haven't seen the actual legislation, and this may result in many, many applications. So people should not be thinking that there has been a blanket amnesty or pardon invoked. They still have to go through the pardons process, and even if they are granted a pardon in this sort of situation, it is still subject to revocation in certain instances. So they have to be very aware of what the actual legislation will say and its actual effect.
The government makes the case that past cannabis convictions are not historical injustices, such as the charges laid against members of the LGBTQ community in Canada decades ago that are now being expunged under recent federal legislation. Is that a valid argument, given that cannabis charges have historically targeted racial minorities and youth, and the government said that's what it wanted to wipe out? Can you say that these are not cases of historical injustice? Does that argument hold water for you?
I can certainly see a distinction between a conviction for use of an illicit substance and discrimination about an immutable characteristic that a person has. Those are two different things, and the government's position could be justified on that.
Okay, let's talk about the legalization process itself. We're into it now, full bore. The CBA, though, and I know you still have serious concerns now that legalization has arrived, and one of them is the notion that, hey, legalization means it's kind of the Wild West now, no more penalties, anything goes. What do people need to know about the new rules and new penalties?
The first thing is that people have been misinformed, unfortunately, about the scope of the new legislation. And as you've said, they think that this is a wide open situation where all cannabis is legal. That is simply not the case. There are numerous continuing offenses, continuing restrictions, and severe penalties that may be imposed. For example, if a person gives a joint of marijuana to a person who is under 18, that person will have committed an indictable offense and could face a maximum penalty of 14 years in prison. So it is by no means a totally new world out there. There are severe restrictions, both criminal penalties and regulatory penalties. So
in some cases, are penalties harsher under this new legislation?
Not for cases like trafficking, which now has a maximum penalty of life imprisonment. It's reduced to 14 years. But there is an area where there are going to be significant new penalties, for example, under the regulations. Regulatory offenses often carry severe penalties in order to ensure industrial compliance. And a breach of the regulations could mean a fine of up to $5 million or 3 years in jail, or both. So there are severe penalties in this area, and that is something that has not existed before.
We've heard about shortages in supply of legal cannabis, and we know that young people below the age of 18 cannot access the legal market. What could that mean for the government's efforts to beat back the black market, and what about the penalties for going to the black market?
Well, actually, it means that the illicit market is going to be preserved because young people have no legal access to cannabis. The Act recognizes that some young people will share this drug amongst themselves. The government has made a decision to make sure that there is no legal source in order to protect young people, in their view. But young people still have to, or will find a way to gain access to the drug. So it preserves an illicit market.
Let me ask you, what concerns do you have? One of the other big issues with the roadside testing process. What worries you about that?
That is a major concern because there are several areas where the regulations have been promulgated. A person who is driving and has a very, very low THC level in their bloodstream will be deemed to have committed a summary conviction offense at only 2 nanograms. The science behind drug impairment is not as developed as the science behind alcohol impairment. So, for example, a person may be driving with a very, very minor amount of THC in their systems and not be impaired in any way and still be subject to significant penalties and loss of license. So this is an area that has to be developed. Also, the testing regimen has to be developed as well, because police forces across the country have expressed concerns. Now, Chief Palmer from Vancouver, who's the chair of the Canadian Association of Chiefs of Police, has said that police forces will be ready. But there is a vast difference across the country in funding and training for police officers. So there are going to be distinctions, and in some areas, there may not be sufficient police presence to ensure public safety.
Right, and we're going to hear from Chief Palmer coming up in our program this evening. Are we going to see court challenges? And if so, what do you expect will be the subject of those challenges?
There's no question that there's going to be court challenges here. In addition to, if I can put it this way, standard challenges that one may face in a criminal prosecution, such as the legality of the police officers, did they have grounds to stop someone, were their actions compliant with the Canadian Charter of Rights and Freedoms, you're going to see areas such as whether or not the equipment is properly used, is it scientifically reliable? If certain instruments are deemed acceptable, have the instruments been operated properly? We're going to see the same sort of challenges that we see in drinking and driving cases all over again. And we have to be aware that this unquestionably will cause delays in the courts. And drinking and driving is already one of the most heavily litigated areas in the criminal code, and I expect that we are going to see many challenges for drug-impaired driving as well.
All right, lots to watch for in the days and weeks ahead. Good to have your time today, Mr. Calarco. Paul Calarco, defense lawyer, joined us from Toronto. Good to speak to you. We'll talk again.
Thank you very much.